Hi everyone, thanks so much for joining us. It's our mini Pupillage webinar. We've got a great panel for you. Unfortunately, only 4 of us rather than the 5 we expected because our colleague Harriet Dudgebridge isn't feeling too well. While I think of it, she's asked me to tell you that if any of you have got any specific questions for her, then she's happy to answer them by email. So do get in touch with her directly. You can find her email address via the website. Thanks as well for all of your questions. This really wouldn't have been up to much if you hadn't given some real thought to those and asked us some really good ones. I'm really looking forward to hearing what everyone has to say about some of those, and we'll get through as many as we can. We've also got a chat function, the live Q&A. I can see at least some of you are on that already asking questions. If anything crosses your mind, do stick stuff there and we will do our best as well to answer those while we go. Keep an eye on them. You might find that we'll be writing answers rather than talking about them. In a moment, I'm going to ask everyone to introduce themselves, tell you a little bit about their route to the bar and about their practice areas. And then we'll get into the question and answers. We're going to touch on things like our application process, what it's like in chambers for women and for ethnic minorities and for pupils. We've got a really good varied panel here, so I'm really interested to hear what everyone has to say. My name's Ben Hamdy. I'm a personal injury barrister in chambers, and I'm also, for what it's worth, head of pupillage at the moment. So hopefully I can give you a bit of insight into that side of things. Why don't we start by asking Natasha to tell you a little bit about her.
Hi everyone, so I'm Natasha Dzameh. I'm a barrister in the Commercial and Chancery Department. What that means is that essentially my practice consists of commercial work, wills and trusts and property. In fact, I find that my practice is heavily commercial and wills and trusts with a little bit of property. In terms of my route to the bar, I went to a state school and then went to a non-Oxbridge university to study law. After that, I went straight into my bar course in Leeds. And then after that, I worked in a law firm for a year in personal injury and insurance, discovered that I definitely did not want to practice personal injury, not to offend Ben. But after that, I then went back to university, went to the University of Nottingham to study international commercial law as a master's. Then I spent around a year looking for work, not wanting to go back into the PI side of things, really wanting to go into a firm to do commercial. Found it quite difficult to get a job in that, and so I ended up working as a county court advocate for 2 years, and then I started pupillage at St John's.
Natasha, can you tell us a little bit about your sort of day-to-day life as a commercial barrister? What's your practice like?
So in the commercial and chancery team, generally, it's more of a paper-based practice rather than a court-based practice. I had a slightly different kind of practice in the sense that I seemed to be in court on average twice a week, which is quite a lot for the commercial and chancery bar. But obviously now with the COVID situation, it is very heavily paper-based. There are some hearings that are happening, generally by video or telephone, but nowhere near the level that they were before.
Jacqueline.
Hello. Hi, I'm Jacqueline Humphries. I'm a member of the family law team at St John's. My route to the bar was also state school, but then Oxford, a year out doing something unrelated and academic, and then back to bar school and pupillage in a specialist family set in London, who binned me at the end of the year, and I then did a third six at St John's and became a tenant in St John's in about 1995. So I've been doing this job now for a little longer than the rest of the team. Best part of, gosh, yeah, 25 odd years. My practice in family, having done a really broad base of sort of all family law, public and private law children work and financial remedies work, I now specialise pretty much in financial remedies. I do a little bit of private law children work. The financial side of family work is not just the finance after divorce. It includes things like trust of land applications for unmarried partners, arguments over home ownership, occasionally Inheritance Act questions, such things like that. The type of work, there's a fair amount of paperwork, but it is more court-based. The family department generally are very court-based, probably only criminal barristers are in court more than the family bar. So within St John's, the family team are the ones that are in court the most. Within family finance, to actually get to a final hearing is actually quite rare, because what you're trying to do for the benefit of your clients is to settle the case on sensible terms, because the pot that you're trying to share between the parties, if it all gets spent on the lawyers, it leaves nobody with anything much to live on out the other side of the split. And so except in sort of pretty extreme cases, you are always trying to look for a pragmatic solution. So you have a lot of interlocutory hearings, you do a lot of negotiation, you have a lot of conferences with your clients, trying to help them to find a sensible way forward. Yes, obviously there's advocacy, but it's the final hearing trial advocacy is there, but is not as frequent as in other areas of practice.
Hi everyone, I'm Dan Soar. I in quite a nice contrast to that, have been doing this job for all of about 2 weeks. I have just finished my pupillage at St John's. I was the Chancery and Commercial pupil last year, so I've just finished and started practice, which is exciting. My journey to the bar, I again went to a state school, went to university up in the northeast, and studied law. I took a year out afterwards to do something a bit less high stress, and then came to Bristol to UE to do the bar course. And then it took me a little while to find pupillage after that. I worked for about 6 months with a very stressful construction law and claims consultancy, and worked for a guy who was very angry, and I basically filed papers and photocopied bundles for 6 months. Yeah, I stuck at that for about 6 months, and then I moved on. I did some county court advocacy. Most of you have heard of LPC law. I did that for nearly a year, and that was really good experience. And then after that, I found a job with Bristol City Council, and I worked in their legal team for a year, and that was really good. I worked in their commercial legal team, so that was good commercial experience. And then I got my pupillage at St John's, and in the year, often it's given 18 months in advance, so I went to France for the year and did something completely unrelated before coming back to Bristol and starting pupillage. Yeah, that was my journey.
Dan, can I ask you, you're just fresh out of pupillage, aren't you? So why don't you tell everyone a bit about what it's like, day-to-day life in first and second six?
Sure, yeah. Well, first six, I had two supervisors throughout my year. I had one in first six and a different supervisor in second six. My first supervisor was a guy called Chris Jones, and I shadowed him for the first 6 months. So a lot of that for me looked like following him around to different court hearings that he was doing, or mediations, or client conferences, and basically attending, taking notes, and really just observing. There wasn't too much pressure on me to, take a minute of everything that was said. I could sort of sit back and observe what was happening and learn, and then have a really good opportunity afterwards to ask any questions. And when I wasn't doing that, actually out and about somewhere, then I was doing paperwork for Chris. So he would literally just give me what he was working on to do. So I would do what he was doing, and then he would look after it, look over it afterwards, and give me some feedback. So amazing opportunity actually to do some work, not just on sort of a base level, newly qualified level, but experiencing the work that a barrister does after 10 or 15 years practicing.
And
so
then, of
it's some really interesting work.
Of course, your second six basically coincided with the start of lockdown, didn't it?
Yeah, almost exactly. Yeah, so the first month of second six, a lot of the courts shut. Some hearings went ahead by telephone and video, but a lot of them were put off. So it was certainly an odd start to second six, a little bit anticlimactic. You're sort of expecting the rush and the thrill of being in court for your first time, and traveling up and down the length of the country, and it's all supposed to be very exciting. It wasn't exactly like that, but it was still really good. Still had lots of opportunities to attend hearings remotely, and if I didn't have hearings on, then my supervisor could give me written work to do, and being Chancery Commercial, there's always a lot of written work, so there was no shortage. And since August, September, we're sort of back to pre-lockdown levels of work. So that's been really good. I've been really busy last couple of months. Still a lot I've been doing remotely. Have started going to court a few times, but still a lot of it is remote. But been really busy, so it's been good.
Yeah, it's one of the things I expect we'll touch on a bit more later, is the way that practice has changed in the last few months. All right, so I'll tell you a bit about me. I went to state school as well, so you've got a full house here. We were pretty normal. My dad was a policeman and my mum was a medical secretary. My brother had been to uni, but we were first generation in our family to do that. I went to uni in Manchester, and by about midway through third year, had no idea what I was going to do. So I took a risk and got a huge loan and did the bar course. And I was lucky enough to get a pupillage at a common law set in Liverpool, which was mixed criminal work, personal injury work and family work. So I did a bit of all of that to start with. Had 5 great years up there, and then decided to move back to Bristol. So I've been at St John's now for 7 years, and I'm now very much a personal injury barrister. Sorry, Natasha. I love it, actually. I love it. It doesn't get the best rap sometimes, because there's that view, certainly, of the industry as being all about where there's blame, there's a claim and all that. But genuinely, when you've got someone who's seriously hurt and really needs help to get their life back on track, it can be a very, very fulfilling job helping them do that. And there's a lot of law in it, and there's a lot of court work in it, and there's a fair bit of paperwork in it. But we're probably in court a bit less than the family bods, but a lot more than the commercial and chancery lot. I'm also now just recently head of pupillage, so I'm in charge of, with a lot of help from Natasha and other members of the team, in charge of our application process, which is one of the things I'm going to talk to you about. In fact, why not now? Because one of the questions we've had from you was what were the most important criteria that we look for in candidates for pupillage. And there's no secret to that, actually. In fact, very soon, I suspect we'll be publishing our pupillage policy, which will tell you in black and white exactly what we're assessing when we interview candidates. So we're looking for people with a good academic record, obviously, ideally experience of work, whether that is proper work, you know, we're actually in paid employment, or whether that's work experience like many pupillages, like time in solicitors' offices, that kind of thing. We're also interested in people who've done voluntary work. It might be legal based, it might be that you're working for Citizens Advice Bureau or on a help desk at university. Some universities have things like that. We're looking for people with a real desire to live and practice in Bristol and come to St John's Chambers. And those are the kind of things that we ask you to talk about in your written applications for pupillage. And that's stage 1 of the process. If you get through that sift, through that part of the process, then we have 2 rounds of interviews, about half an hour long, the first one, and then 45 minutes long, the second. And in those, we ask what we call competency-based questions. And basically what we've done is sit down and decide what we think makes a good barrister it's really tricky because there's a lot of things, and it's very different in different roles. But we think that things like data processing, getting to grips with large amounts of information and being able to absorb it quickly, working under pressure, of course, advocacy. We have a couple of advocacy exercises in our interviews. Written communication, verbal communication, tailoring your communication to different audiences can be really, really important. And then things like resilience and determination. One of the things that I'm going to ask my colleagues to talk about in a moment is work-life balance, because it's a hard job. And we are interested in people who have learned to manage their time, to give themselves a break, you know, to work hard, but also to be able to cope with the demands of work by giving themselves time off, I suppose, and learning how to manage work. So those are the sort of things we're looking for. Why don't we move on to ask a couple of your questions then? First one I'm going to direct to Jackie and Natasha, if I may, and it's this. What can you say about your experience as a female in the industry? Which one of you wants to field that first? Jackie. You're muted, Jackie.
I've taken this question first because I guess I've had quite a long time and I've seen a fair few changes in terms of greater numbers of women at the bar, greater proportion of senior judiciary being female. And I'm also fortunate that despite having been at the bar for a long time, I've not had very much in the way of direct and unpleasant experiences. I have, however, plenty of friends and colleagues who have, and I'm not naive to the suggestion that, you know, I don't think that the bar is immune from the general problems that there are in society as a whole. I would like to think that things are getting better, and I would hope that the junior end will be able to tell me that it's wonderful and there's no concerns at all. I somehow doubt it. But what I think is better now than would have been 20, 25 years ago is that there is more of a culture of inappropriate behaviour being disapproved of and being dealt with, and there are better structures in place for dealing with those issues. Although, frankly, a lot of the time you just have to find a way of avoiding it or dealing with it as best you can, and with the support of the people who depends what you talk about, the practical support of the people around you and your friends and whatever, and then also using the systems to challenge it if that's what needs to be done in your particular circumstances. From a positive point of view, what is good about the bar as a profession is that it has a lot of flexibility in terms of how you use your time, and because it's compared to many other professions relatively well paid, again not as well as now as it used to be, but still compared to many other things that we could be doing reasonably well paid, it gives you the degree of flexibility. So if, and this isn't just an issue for women, it's an issue for anybody who's a parent, if you want to have a fairly hands-on role as a parent and spend increasing time with your family when they're young, because you're self-employed, there is a level of flexibility in that you can take time off during school holidays, you can make sure that important days that you haven't enough notice of, you can take out of court. However, the flip side of that is that if you've committed to a particular case, then you are committed to it, even if it runs on, overruns, crashes against important events in your children's lives, important family holidays, all of those things. If your case runs on and you're there, then you can't always get out of it. And once you've made the commitment, you have to stick to it. So it's not perfect, but if you are careful in managing your time, it can be a profession that's quite good for parents. But obviously, if you're taking the time out to do that, then the level of earnings is not the same that if you're working more time. So, but because it's so well paid, it has, relatively to many other professions with that kind of flexibility, you do have the opportunity to have quite a good work-life balance if you're able to organise it. But you can't expect that in the very early years, and you have to guard it quite jealously, because there is always pressure to do more. So that will be my contribution.
Natasha, what about you?
So the thing that I find quite noticeable is when you compare the practice areas, commercial and chancery still has relatively few women in. So it's better in London in terms of the number of women that tend to be in the area, but certainly I've been practicing now it's been 5 years since I started in chambers, and my opponent has been female a handful of times, if that. So it's very rare that I'm against another woman. Insofar as specific problems, I think you've always got the concern of being someone who is self-employed as to, okay, am I being paid the same as, say, a man would be for this case? But actually, most of the time you can see the statement of costs, and so you know whether you're being paid roughly correctly or not. And that has never been an issue for me. I've never found out that actually my opponent's getting significantly more than me when they're roughly the same level. So that's not a huge problem. The slight weirdness that I've had is certainly there was a time when someone had called chambers to instruct someone for a case, and I'd been suggested, and they'd asked the clerk, well, to what extent does she know about cars? And this is a case where we went back and said, well, look, is there going to be live expert evidence on this? And they said, well, no, there's an expert report. And so realistically, you can't think that it's incredibly important that the barrister needs to know the ins and outs of cars, because otherwise there would have been a conference with the expert prior, or there'd be live expert evidence, because all the judge is going to have to go on is going to be that expert report. And so the view was very much taken between myself and my clerk that actually what they meant was, can we have a man? To which the answer was, well, no, Natasha's the person that we're putting forward, and that's the end of it. Ultimately, they came back and said, oh, it's now settled. Whether it actually settled or not is debatable, but we didn't suggest anyone else. So in that sense, Chambers is very supportive, but that's only ever happened on that one instance. There is certainly someone who's instructed me and who has instructed other women in Chambers who the general view is the way that we're spoken to, or the way that our views are taken, suggests that he doesn't really know how to instruct women, or certainly doesn't consider your opinion as highly as he would if you were male. But again, that's only one person. Beyond that, I don't know that there have been any specific issues. I suppose it's just slightly strange when you're working in an area and you almost never see another woman. Because when you look at law firms, particularly in commercial and trust and property, there are lots of women. It seems to be a problem at the bar. And one would question whether that has been a status quo that's been maintained, because stereotypically it's considered the highest paying area of law. And so women are potentially kept out of that in some way. That's my only query over that.
Do you feel like that's changing, Natasha?
I mean, in the time that because I've been against female opponents so infrequently, I can't really say. I think certainly when you look regionally and you look to London, there are more in London, but there still aren't, even at the upper levels, there aren't tons of female silks in commercial and chancery. There aren't loads of female juniors. So I think it's something that's gradually getting better, but I'm not seeing a huge shift.
I suppose one of the ways we as chambers can make that better is by making sure we've got good processes for interview and so on. Can you talk to that a little bit?
Yeah, I think that the interesting thing about RSIT actually is, so after I was recruited, the next person after me in our department was in fact, I believe Emma Price. Then it was Annie Sampson, then Georgie, and then Dan. So we've had a few years of all women in my team, but equally I am the most senior woman in my team. So it is one of those areas where in general there are very few women, and hopefully we're progressing in such a way that that's changing, but time will tell. Okay,
let's talk about this, and I'll ask Dan to deal with this first, if I may. What is a skill or part of the job of being a barrister that you think is forgotten by most people
Well, I suppose this is perhaps illustrated by what I was doing this afternoon, which was doing my VAT return. So one of the skills, it's an exciting Friday afternoon activity, but one of the skills as a barrister is that you are self-employed and you have your own business essentially, which is you providing the services that a barrister provides, and you have to be responsible for maintaining and administering your business. So that means tax. That means you're doing your own tax, doing your own VAT. Of course, you can use an accountant to do that, which you may want to do when you're perhaps a little bit more senior than just out of pupillage. But there are lots of different aspects of it. So recently, we've been doing quite a lot of GDPR seminars because, of course, we're data controllers and data processors. So there's quite a lot of considerations on the data management front. I think and then there's the insurance side of things. One of the things what I'm trying to say is that there's quite a lot to hold in balance. We don't just give legal advice. We don't just appear in court every day, but there is an aspect which you have to manage your own practice, manage your workload, for example. So be aware of how much work is coming in, what hearings you've got scheduled coming up. A balance that I have to strike at the moment is I have quite a lot of hearings in my diary, but I also have a lot of paperwork coming in, and so for me it's a balancing act of well, how much time does a hearing take to prep? Obviously I'll have to, well, not at the moment, I don't have to travel, but in ordinary times I might have to travel a couple of hours to get there and back. And then also I've got paperwork which clients are wanting a quick turnaround on. So there's quite a lot of demands on your time. So time management is really key. I think in answer to your question, Ben, that those would be two skills, time management and good admin, that I would sort of highlight as perhaps underrated skills.
That's great. Thanks, Dan. How about you, Jackie? You're muted again.
Sorry, so you can't hear the cogs whirring while I'm thinking. I think the thing I would want to say about an underrated skill is the soft skills and the people skills. Yes, you have to know your case. Yes, you have to know the law. Yes, you need to know what your good arguments are and be tough and tenacious where you have to be. But actually, this is a workplace. Your opponents are also your colleagues, and being pleasant, polite, friendly, helpful goes a very long way. And if you're vile to your opponent one week, next week you might find yourself in front of them. It's also hugely important to be respectful and pleasant to not only opponents and judges and clients, but things like ushers and court clerks and security guards and the people who keep the courts operating, and who far too often are on the receiving end of high-handed and unpleasant, impatient, stressed out barristers, thinking that they owe them a favour. And it never does you any favours, because if you're particularly bad to the court staff, the message gets back to the judges anyway. But actually but even without the pragmatic element, it's just a far better way to live. And will get you a lot further in terms of that time when you need a favour, when you need something photocopying, when you could do with the list going in a slightly different order to the way it was being expected. If the ushers know you and like you because you're pleasant and respectful, it's amazing how often things can be speeded up to get your case in quick if you needed somewhere else later, or if you need a bit more time to sort something out with your client, they'll put something else in first, and so on. It is absolutely worth remembering that everybody that works in the system is important, not just the ones that sort of are seen as the high profile ones.
Natasha?
So I'm going to assume that the question was about an underrated skill, because I had to nip off and take a phone call from a solicitor while you were talking.
That's right.
I would say patience, because actually when you're training, you assume that there's a chain of lawyers that are involved. You'll be instructed by a solicitor, and you assume that everything will come to you in a certain format, having been prepared in a certain way, and that all you've got to do is essentially your portion of the job, or what you'd envisaged is your role. You will find a lot of the time that actually you're looking at something where either things have gone wrong, maybe someone should have come to you earlier, maybe that's because the solicitor felt they could do it on their own, or maybe that's because the client was reluctant to instruct you earlier, didn't want to spend money on counsel's fees. And so actually what comes to you at times can be quite a bit of a mess. Equally, you can be instructed at quite short notice, and so you need to be able to deal with that and have the patience to go through the documents and prepare for court. It's not uncommon, and I've certainly had a situation before where I was instructed for a trial on a construction matter on around a Thursday, with the trial being on the Monday. The paperwork was an absolute nightmare. The case had been pleaded in a way that made literally no sense. My instructions made no sense. I had to organise a conference with the client, who really couldn't explain his case to me. Definitely couldn't explain quantum, because he had an accountant and the accountant dealt with quantum. And for some reason, the way that his solicitors had pleaded it was a combination of, in terms of the figures, the other side's invoices and my client's invoices, so it made no sense whatsoever. I ended up having to get him to attend court around an hour or two earlier than I normally would, so that we could go through his paperwork. He attended with a hold-all full of documentation, which included a variety of architect's plans, and so it was evident that these were essential to his case. The pleaded case, however, was essentially this invoice was issued, it wasn't paid, and that's the end of it. And actually his case ended up being about a number of complicated matters, such as oral variations, the scope of the works, whether certain variations were in fact agreed, and so on. None of this was in his pleaded case, none of it was in his witness statement. And so then I was having to kind of struggle to get all of this into evidence in examination in chief, which you're not supposed to do, and so unsurprisingly I got told off by the judge. And then we got to the point where partway through, the judge made a comment about the way his solicitors had pleaded the case, and essentially said, look, I deal with these kinds of cases on the small claims track with litigants in person, and this is possibly the worst pleaded case I've ever seen. So then I had to ask for permission to have a chat with him about the possibility of professional negligence, because he's mid-evidence, I couldn't just have a chat with him. But as you can imagine, on the day, that took a lot of patience, and also in terms of the preparation. So I'd say that's one of the key skills that you're going to need.
Thanks, Natasha. For my part, I would say that the thing that is most underrated, or thing I didn't appreciate until I started doing the job for a few years, is that the practical side of things is so much more important than the legal side of things. You know, you come into pupillage thinking, I've got to get the law right, I've got to, you know, win everything in court, when actually 99% of cases, probably way more than that, don't get near a courtroom. And so the real skill and the real sort of mental adjustment you've got to go through in the early years of practice is approaching cases in a real world practical sense rather than just a legal sense. It's actually getting the answer that everyone can live with. It's not always the best case, but it's often about managing expectations, about considering it's about considering what the court can give your client and whether actually that's what your client needs. A court very often can give you money, say, if you're a personal injury claimant, but often what a personal injury claimant really wants is an apology, is some recognition. And so if you can approach the case in such a way to secure that for them, then you don't need to go to court. So that's what I would say is the underrated skill of a barrister. Let's talk about something else. We've had a question: what preconceptions did you have before starting a career at the bar? And have any of these proven true or false? Why don't I ask Natasha to deal with that one?
This probably just goes back to my answer on the other question, which is that I'd assumed that everything comes to me nice and tidy. And so actually, I wouldn't be doing that much insofar as trying to rectify errors. I would just be dealing with advancing my client's case. And in fact, a lot of the time you are trying to remedy an error that's been made, which was surprising just because when you're taught on your bar course how this all works, no one ever broaches the idea that someone may have messed up somewhere earlier in the line and you've really got to deal with that. It's always presented to you as though everything will be perfect when it comes in. And I'd say more often than not, it's not.
I certainly felt when I started out that it was going to be really glamorous. Walking around, wigs and robe, pink tape, all that stuff really isn't like that. It's more magistrates' courts or you know, civic court buildings. They aren't glamorous places, and very often you're having a quick sandwich in the car or on the train, you know, desperately trying to prepare the next case. The other thing I thought I would love from the off was being in court. I thought I'd love it, and I really didn't to start with. I really struggled with nerves. I was terrified. I would say I really hated it to start with. And actually, it was only when I realised that I could perform in court despite the nerves, that hopefully they didn't show too much, that it wasn't affecting my performance. And that sort of created a positive feedback loop for me, because then the nerves went, at least to a large extent. They're always good, actually. I'm sure everyone would agree. Nerves keep you honest. Nerves keep you, give you that little edge that you sometimes need. What about you, Jackie? What did you think?
I think one of the assumptions you have is that judges know everything and they're going to get it right, and they've just got this vast wealth of information. They're just so amazing, clever people. And whilst it is true that many of them are lovely and amazing, clever people, nevertheless, you don't know everything all of the time. And actually, the judges do rely on barristers to genuinely to help them, and that and therefore doing a good outline that identifies the relevant legal points and cuts out the rubbish is actually very valuable, and they really do benefit from the quality of the people peering in front of them. And the other thing, of course, is actually, and perhaps is more the case for family law, was a lot of what I deal with is quite a discretionary jurisdiction, when judges have to do what is fair within a range of, balancing a range of factors, rather than a more sort of black and white, is this legally possible or not. The humanness of judges, I think, is something that you learn more about as you go on, particularly as you get more senior and you end up appearing in front of people that you've been colleagues with and so on. And I think, yes, how it matters quite a lot who your judge is, and knowing them and knowing what their preferences are is valuable when you can have it. It's not essential, because obviously you always have to go to court in a new place, and you don't know it from the off, and sometimes you're in front of lots of different people every day of the week. But just getting a sense of the humanity of judges, I think, is actually a really useful thing.
What about you, Dan?
Thanks, Ben. I think for me, I had a sort of preconception that every case was winnable, and actually if I didn't win, then I hadn't done my job very well, or it meant that I wasn't a very good advocate, or I hadn't done enough prep. And I think quite quickly I've come to learn that actually every case is so different, and that's one of the joys of the job, really, is the variety of it. But often you're dealt a losing hand, and you do the best with it that you can, and you can do the best advocacy and still lose, and that's okay. And I think from a perspective of job satisfaction, it's really important actually to be able to appreciate what you're doing in your work, even if you don't get the outcome that you were hoping for or that you want. And I think a lot of barristers struggle with that, because we're generally quite a competitive bunch and we love to win. But I think recognizing that you won't win every case, and that's not necessarily a reflection on you, that's been a helpful realization for me.
Can I
Jackie?
can I just add to that, that actually when you get more senior, it's actually quite nice when you get a case where you look at it, you think there is absolutely nothing I can do that's going to win this case. Because then actually every bit of gain you make in terms of whether it, you know that your main case is hopeless, and therefore if you can negotiate something that gets your client more than the other side want them to have, or if you can, get a little bit more contact or whatever, even if your application for moving the residence of the child is obviously hopeless. But in some ways it takes the pressure off, because if you've got a case that ought to be a dead cert winner, or where it's finely balanced, those are the ones where you do feel that you've got to put because if you lose a dead cert, it's horrendous. And if you've got a finely balanced one, you really feel that you have to put in every last little bit of effort to make sure that it just tips your side. Whereas if it's a dead set loser, it's brilliant, because actually, there's nothing more you could do. You obviously have to do your job properly. You have to prepare the client for what is likely to be the outcome. And if you do that well, then if you get some improved situation for them, then in many ways that's a good victory. But it doesn't half take the pressure off if you're pretty certain you're onto a loser when you've opened the brief.
Yeah, it's funny, isn't it, how sometimes you can walk out of court feeling pretty good about what you've done that day, even though you've had an absolute battering on the case. But you're very happy with a particular bit of cross-examination or a particular way you dealt with something in submissions or costs or whatever it might be. And equally, you can win a case and walk out of court thinking, I was useless. I've added no value there whatsoever. We've had several questions, both before and also during this on the live Q&A about international students. And I've gone away and looked at this today, and it's in quite a lot of detail, but the gist of the questions was, do we take on international students, or would we, I suppose, in principle? And the answer to that is yes. I think on our application form, you will notice that there is a box you have to tick about whether you are entitled to remain in the UK. And to some extent, that's a question that's outside of our hands, of course. But what I can reassure you on is, A, provided you are entitled to stay in the UK, there is absolutely no way your status would be held against you. It would just wouldn't fly. It wouldn't be one of the things we'd be allowed to consider, let alone that we would. Also, in terms of the minimum earnings you need to have to secure a visa, our pupillage award exceeds that. And I also know, having spoken today and getting a bit more clued up about it, I know that the Bar Council have specific provision for this. So without knowing your specific circumstances, I don't know if it's several people, I don't know if it's the same person asking the question, but without knowing your specific circumstances, it's quite tricky to say more than that, I think. But if you want to contact me by email, and we can have a chat about your situation, I'm sure I'll be able to help you more. As I say, I've been looking at this in quite a lot of detail today with the Bar Standards Board and also the Bar Council. But the short answer is, yeah, we take international pupils on. Right, so let's deal with a COVID thing. We're sat here now having a virtual chat at 6 o'clock on a Friday evening. The question is, do we think that a move towards virtual hearings and telephone hearings is going to be a permanent fixture now? And if so, how do we think that's going to affect our working lives? Why don't you deal with that, Natasha? How's it affected you in the last 6 months? What's it been like for you?
So I used to be in court about an average of twice a week. Since the COVID situation started, so going back to April, pretty much all the trials that I was scheduled to undertake were adjourned. So my earliest trial now is January or February next year, subject to things that come in last minute. Most of the hearings tend to be interim hearings, so things such as directions hearings or applications, but there aren't as many of those as there were before. There's certainly not the volume of work insofar as court work's concerned, but the amount of paperwork has gone up quite substantively. So what I'm tending to find is I'm still insanely busy. It's just largely with papers rather than court. Certainly at the beginning, it seemed as though papers and court may be going off for quite some time, but it ended up being, I'd say, about 6 to 8 weeks where that was the case, and then everything just came back, or at least all of the paperwork came back. Insofar as in the long term, a number of judges have said that we will never be returning to the position of doing as many in-person hearings as was the case before. I don't really have a huge problem with that, provided the number of hearings comes back. Personally, I tended to mainly be working on the Western Circuit or in Wales, but I used to occasionally travel to Manchester and then quite often to London as well for other hearings. Ultimately, this just means that I don't have to get up as early and I can switch the laptop on, so it's quite nice to do that instead.
Yeah, saving the hours in the car and on the train is quite nice, isn't it?
Equally, I quite like for mediations, those are now more often than not virtual, and actually that tends to be much nicer than doing it in person because it's more relaxed. And with a mediation, most of the time you spend sitting in a room waiting for someone to make an offer. There's a flurry of activity when you make your counter offer, but in between there's just very long periods of what seems like everyone doing nothing. And so now instead your clients can go and have a wander around or do something else in the meantime, rather than just be stuck there waiting. And I think everyone tends to prefer virtual mediations now.
Do you find it difficult in sort of engaging with your clients and building rapport with your clients using virtual platforms?
I found it okay so far, actually. I haven't found that that's made a significant difference in that respect. The one thing I dislike, and I haven't yet done a full trial by video, having dealt with an application, and this was kind of at the start of the court doing the video hearings. I had an application where a few hours in, we still hadn't managed to get everyone on the video. And ultimately the judge turned around and said, well, look, we'll use Zoom rather than using Teams, which is what everyone was trying to use. And then once we'd finally all got onto that, he said, well, I actually don't need to see any of you. So we could have just dealt with it by way of a telephone hearing and then been done by that time. Now, I'm hoping that most courts have had enough experience with the video hearings that isn't usually the case. But having not dealt with the trial or any really significant video hearing since, most of mine have been by telephone, I do wonder whether there'll still be problems in that respect.
Dan, turning to you, do you have anything to say about that?
Yeah, I think as a second six pupil and in early practice, I do a lot of pretty short hearings. So I do some hearings called MOJ Stage 3 hearings, which can last anywhere between 10 and 30 minutes. And I do those all over the Western Circuit and Wales, South Wales, into the valleys and some quite far-flung places. And if I had to drive or get the train there, it's a real effort to drive a couple of hours, do a 20-minute hearing and then drive back a couple of hours. So being able to just do it from home is a huge benefit, really. A huge benefit, saves a lot of time. I think it is funny doing a cross-examination, for example, over video. It's not quite the same as being in the same room with a person, but I think probably the benefits outweigh the drawbacks if the court can get on top of the tech and the rate of failed hearings comes down, because I do have quite a few hearings where they just fail because the tech isn't functioning properly, but I'm sure that would be resolved quite quickly.
Jackie, are you there?
Yeah, one of the things I think it's quite interesting to discuss isn't actually my own experience, because I mainly do the finance side of it, but the people that do public law children work, care proceedings, have pretty much had to keep going with full-on hearings throughout the lockdown. Now, most of those have not been in person, although some of them have. And what they have also done is a number of what are called hybrid hearings, where some people are in the court building and some people are attending remotely, which also throws up complications. The problem was, of course, is that whilst with family finance cases, or indeed most commercial chancery and many other types of case, whilst it's unfortunate and undesirable, if you adjourn it for 6 months, it's frustrating, but it's not a disaster. If you're working out whether a child needs to be removed from its parents for its own protection or returned to them having been removed, then an extra 6 months in a child's life is massive, and therefore delay in public law children proceedings absolutely has to be avoided. You know, if you need to have court permission to take a child out of a dangerous situation, then you need to get on with it. And that's thrown up some really quite tricky issues, because of course the people who, whilst not always but often, are on the receiving end of the state's desire to remove their children are often people who also have limited resources and limited ability to engage with the kind of remote hearings, either in terms of the capacity to manage with them, or even having access to the technology required to physically access them. So there's been a lot of so the family team in particular, the public law family team, have actually been in chambers throughout a lot of the time in lockdown, and some of them actually physically at court as well. Either having hybrid hearings where client and solicitor and barrister are all present in one room in chambers, sharing a socially distanced, sharing a video link to a court where a hearing's going on. And then sometimes you have individuals, particularly the parents in care cases, giving their evidence live in court so that they can have the best opportunity to give the best impression to the judges, whereas the professional witnesses like social workers and guardians and so on giving their evidence remotely. And whilst that's not very good in terms of even-handedness, it's seen as being the least worst option, because professionals are usually better able to cope with the additional layer of complexity of the technology, rather than expecting the lay clients to do that as well. So that's been a particularly unusual set of circumstances, which hasn't been without its problems, and there's if anybody listening is interested in family law, particularly children law, if you don't already look at a blog called Pink Tape that's written by one of our colleagues in Chambers, Lucy Reed, I really very strongly recommend it, because it really gives you a good insight as to how that kind of legal practice works and some of the issues and how they impact on the clients as well as on the professionals involved. And it's a very useful and very insightful blog, and I'd very much recommend that to anyone who's interested in the family bar.
Yes, that's a great point. Lucy's blog is brilliant. And that also reminds me that I should say that our colleague Rachel Seagal was on a podcast called The Legal Ladder this week, or last week. It's called The Legal Ladder, and it was episode 4, and I listened to it and it was fantastic. She's a really, really interesting woman, had a really interesting path to the bar actually. She was a professional musician, amongst other things. And she talks in a really interesting way actually about her route to the bar and her day-to-day practice. Dan, maybe this is one for you. What's the relationship like, I suppose at St John's, but just generally, bearing in mind the audience of people who, a lot of them might be in their first year of uni, so they really are new to this. What's the relationship like between pupils and junior barristers and very senior barristers?
Generally really good. I think in St John's itself, one of the reasons I applied to St John's and wanted to come is because of the good relationships that I see amongst the members, and I felt really welcomed into chambers by people of all ages and calls, and that's been I found that to be quite significant. Actually, when I did minis at different chambers, and I found that not always to be the case. So it's something I definitely recommend considering when you're thinking about who you're going to apply to look for, where has a really good culture of good working relationships. I think being out and about, I've come across obviously a lot of other junior barristers, but also people more senior than me, and generally people treat you really well. And a few times I've sort of said, look, I've just finished my second six, or this is the first time I've done this sort of hearing, and the response has been really good. No one sort of looked down on me or sought to take advantage at all. Actually, people have been really encouraging, really welcoming to the profession, and I've had a very good experience on the whole. Does that answer your question, Ben?
I think it does. Natasha, have you got anything to say about that?
So just briefly, one of the things that I think is particularly notable is at some sets you can feel that there is a massive divide between the juniors and the silk or silks. I don't think we have that divide here at all, or certainly not in my team. There are a number of times that I'm perfectly happy to go up to Leslie and ask him about work things, but then equally I have been to the pub with Leslie on a number of occasions with people who were his pupil, and so he's really friendly. It's a very different dynamic to what you tend to get at a lot of other sets, I think, in that respect, because there often is that sense of there being a divide. I'd say that regardless of your level, there is always someone that you can speak to about work, but also about non-work things, particularly at the junior end. Certainly pre-COVID, we all went out quite often to go and get dinner or drinks together. And so I think we have a very good sociable atmosphere in Chambers. Also, when I was doing my pupillage, so there's someone else in Chambers that did his pupillage at the same time as me, which is Marcus, who's in our PI department, so personal injury. And we would find that we had friends doing pupillage elsewhere who sometimes would be texting us because they were really upset or coming to us in tears. And there's a point where he and I just had a chat and thought, actually, we've been really lucky because we have never felt like that during the course of our pupillage.
That's really interesting. Natasha, while I've got you, sorry, Jackie, did you want to say something?
I'm just going to add similarly, because it's not just at the bottom. Further up Chambers, you also need the support and the companionship in it, and it's still there. It's not just, I mean, it's great that the junior end is like that, but you do feel that. You do feel that you're working with colleagues and equals, whatever the seniority, and some people may know more about some stuff, but other people know more about other things. And one of the things that I think was particularly lovely within the family team, I don't know if you guys have done something similar in your teams, but almost the minute lockdown happened, someone in the team set up a WhatsApp group, in fact two, one for the general and one specifically for finance stuff, which we use for a mixture of the kind of things when if you had a tricky point and you'd wander to somebody else's desk and say, can I have 5 minutes and just bounce this idea off you, or have you had a case on this, any ideas? We're now all doing that through a WhatsApp group, and so we're forever sort of messaging each other, and it's actually in some ways even better than wandering, because wandering around the desk depends who's in Chambers, and if you tend to work away from Chambers a lot, you don't tend to be part of that conversation so much, and therefore the WhatsApp group's been fantastic, and I hope that's something that we carry on doing out the other side of the COVID, because it's actually a really lovely way of getting that kind of both professional and personal support.
But isn't that one of the great things about the bar anyway? Working in a Chambers with all these people, you're not employed by anyone, you're all self-employed. Really, if someone sitting next to me in Chambers is doing they're not working that hard that day, it's no skin off my nose. And you can contrast that with an office environment where you're all working in the same team, or you're all employed and you're also maybe competing for promotions and things like that. We don't have the same tensions. We can just get on with each other on a personal level without worrying too much about what Dan or Natasha is doing and whether I think they're working hard enough. I'm sure they always are. But it really does, as an environment, the self-employed bar does give you that opportunity just to sort of relax into your relationships in a way that maybe an employed office environment doesn't. We're going to finish in a moment, I think, with some questions about maybe tips for people who are applying for pupillage and what we like about St. John's in particular. But Natasha, we've had a really interesting question about diversity, which I'm going to ask you to deal with if you don't mind. But the question was this. I know most Chambers will say they're diverse and they're welcoming to minority groups, but from a personal point of view, how welcomed and supported did you feel at St. John's Chambers? And do you feel at St. John's Chambers?
So I've never really felt like that's an issue here. I think the interesting thing, one of the things I was quite curious about is why we don't have more ethnic minority barristers. And so I've been involved in the pupillage interviews for the last, I think, 2, maybe 3 years. And I was looking at the figures a few months ago and I'd emailed Ben about it. And actually, it seems like we just don't really get many ethnic minority candidates applying to us. And I'm not sure why that is, because the courses certainly at UE and the other places in Bristol seem to be diverse or relatively diverse, but we really don't seem to attract ethnic minority candidates. And so one of the things that I'm doing with Annie Sampson is really looking at events that we can host to attract more candidates from those sorts of background, but also more state school candidates and other kind of disadvantaged candidates as well. But yeah, it just seems quite strange that we don't get high numbers of ethnic minorities applying, or even significant numbers. And I don't know if part of that is because there is a tendency, I think, if you are a minority, to look at, okay, who's joined in the last 10 years? And if there is no face that looks like yours, it maybe makes it less likely that you're going to apply. But then if you adopt that approach, unfortunately at the bar, you'll never apply to most places because the bar is very heavily white and male still. So I'm just hoping that more people do apply in future. That's
got to be right, hasn't it? You're absolutely right. If that were the approach taken by everyone, then things will never get better, will it? One of the things that we're doing this year for our applications is we already do redact applications for names and addresses, and with the intention really of trying to limit unconscious bias in terms of ethnicity or gender or where you're from. But this year as well, we're redacting what school you went to and what university you went to. We don't think it's a great marker whether someone went to Oxford or Cambridge, particularly. For all kinds of reasons. The evidence actually doesn't really support that those people necessarily make the best barristers, but also someone with a first from plucking something out of thin air, Reading, may have overcome so many hurdles to get where they were that they may actually have achieved more, frankly, than someone who had every break in life and went to Eton and then went on to Oxford and Cambridge. We're pretty good on our balance of state school. I was pleasantly surprised by the numbers there against private education. It's still over-representation given how few people go to private school, but that's the bar and it's changing with time. We're okay with men and women. Our balance is all right, but for ethnic minorities, this is something that we really, really want to improve in the coming years. And hopefully, like with you, Natasha, and then with other faces appearing that other prospective applicants can relate to and can see that there is a pathway, that'll just keep getting better and better. Why don't we do some pupillage application tips? Do you have any tips? What's your best tip for someone who's thinking about applying for pupillage or doing their applications right now? Dan? No, Natasha, you put your hand up and save Dan.
I would say double check it. The number of times that I've gone through an application that I'm marking and it makes a reference to another chambers, or it makes a reference to an area of law that we don't practice. I appreciate that, having done the application process myself, there is a certain amount of copy and paste that goes on. And yes, for those of you that are doing C&C, you might also be applying for some general common law pupillages on the off chance that you don't get your C&C pupillage. But you need to really double check that. Because if you were in practice and you sent in a set of pleadings that had various errors in, your solicitor is going to be far from impressed. You should be adopting the same approach to your applications. Double check them. Think about what impression you're making on the person who's reading it.
Yeah, good advice. Dan?
I think my advice, there are a few different schools of thoughts on approaching your application. Some people go for do as many as possible and play the odds, and eventually you'll get enough interviews and get an offer. I think my approach and what I would advise is to actually select a handful of chambers that you actually have decided that you really would like to do pupillage at. Perhaps it's better just to start with what are your criteria for chambers, and what do you want your chambers to be like geographically, where do you want to live, what sort of practice do you want, what sort of size of chambers, and draw up some criteria that you can use when you're looking, because the list of chambers can be quite overwhelming, and the number of opportunities out there when the gateway opens is quite overwhelming. So I think have a careful think about which ones you want to apply to, and then put a lot more effort into those individual applications and make them all individual if you can. I think that really pays dividends in the application process.
Yeah, we're well aware that there's an element of copy and paste in pupillage applications. It would be completely unrealistic to think that there wasn't. And actually, a good answer in one is very often a good answer in another. But if you can just think about little things you can do to show us that you've given it thought and it's about wanting to work for us or with us, it goes a long way, really does. Jackie, do you have anything to say about that?
I'm aware that my experience in this is very out of date, as I'm not on the Pupillage committee and it's a long time since I had to apply for pupillage. I have actually applied for other things in my life, and I know when you're producing multiple applications it's tedious, but it is worth reading them and spotting the typos. It is worth getting somebody else to give it a once over to spot the things that you haven't spotted, and make sure you do include the basics of, the basic information that's needed. Actually answer the questions that are given to you. Don't assume that everybody will already know that, oh, because it's so obvious you shouldn't include it, but also do include the things that make you you, and that are unique to you and that are interesting, that are relevant to your hopes and for a future career. I think is about as specific as I can be for my position.
Thanks, Jackie. What about interviews? What's your best tip, Natasha, for preparing for pupillage interviews?
I think with pupillage interviews, you need to be really careful to make sure that you've understood what's being asked of you. So, for example, we will often ask you to read a case or to argue a case. And certainly I've had a situation relatively recently where someone who was academically brilliant, who you would expect to be amazing on this particular aspect, really couldn't explain points of law well, and went so far as to make an assertion about a particular point of law, essentially saying, well, this is the first time that this has been dealt with in this particular area, when actually this particular point was fundamental in this area of law and always had been. And this is someone who had your typical Oxbridge first, so who on paper you would think is amazing. And so what we could only assume from that is that they hadn't prepared as well as they should have. I'd say preparation is always going to be the key for pupillage interviews. You know that there will be some competency questions in every interview, and you'll also be given some form of exercise. And if you've been given the exercise in advance, really make sure you've used that time in advance in the best way possible.
Jackie, I know you're going to say it was a long time ago, but can you think of any hot tips?
It's always worth paying attention to your appearance. You don't have to have any particular style, but whatever you do needs to be neat, needs to be you look like you're awake, alert, focused on what's going on, that you're enthusiastic, that you want to be there, that you've put the effort in. Obviously what you can do on a screen is rather different to what you can do in real life, but one of the things that's always stuck with me from a talk a district judge gave to a bunch of lawyers about the things that kind of lawyers need to remember is that actually maybe it shouldn't be, but it's very distracting to a judge if somebody shuffles into court with their shirt hanging out and their shoes covered in mud and with the remains of their lunch round the corners of their mouths. Those sort of things ought not to matter, but because we're human, they do, and you're there to represent other people. It's not just you you're putting forward, it's them, and therefore you do need to present yourself well, because if you can do that, then you ought to be able to present other people well too. So I think do pay attention to those bits of practical detail.
Good advice. Dan?
Thanks, Ben. I think my advice would be often chambers will publish what they're looking for in interviews and candidates. And I think Ben mentioned that earlier, that we'll be publishing ours soon. And so certainly have a look through that. And then even if you can't anticipate exactly what questions are going to be asked, you at least know what the interviewers are going to be looking for. So bear those in mind, and then think about what experiences have I had in my life that I can draw on to demonstrate those qualities or characteristics or skills, and have a think of that in advance. Because if you're faced with a question in an interview, I remember some of my first interviews, I hadn't really done as much prep as I should have done, and I was thinking off the cuff of experiences I've had to demonstrate certain qualities. And the quality of my answers is just going to be nowhere near what they would be if I'd spent time beforehand thinking about, okay, if I wanted to demonstrate that I can retain a lot of information well, and think about what work have I done, what have I done at university, and come up with some really good concrete examples, then that will set you in really good stead for when you're in the interview, and you don't have to be thinking on the spot. You can draw on some experiences that you've already thought about and known and decided that you actually want to share with the interviewers.
Yeah, there's no secret to that, really. We are specifically and shamelessly looking for you to give us examples from your CV. Tell us about a time where you've had to process a large amount of complex information. Tell us about a time you've had to persuade someone around to your way of thinking, or tailor your communication to another audience. So that's great advice. You need to be looking at your CV and thinking, what am I going to say? What examples am I going to pull from this to show I can do the kind of things that a barrister needs to do? I'm conscious of time. It's 6:10 on a Friday evening, and this probably leads me into a good last question. How do you maintain a good work-life balance? It's Friday. How do you unwind from the stress and rigor of your practice area? I'm conscious I'm drinking red wine. Why don't we go in reverse order for seniority of call, and we'll see if anything's changed over the years. We'll go for Dan first.
I think for me, it's really important to have stuff that you do outside of chambers, to have hobbies that you like to do at the weekends, to be part of a sports club, or any sort of community outside of chambers that you can go. You can see friends, you can hang out, you can arrange to do stuff at weekends that you can actually prioritize. I think especially, for example, weekends, you in the week you might have something come up last minute that you have to spend your evening doing, but at a weekend, even if you've got something urgent for Monday, you can at least be flexible about when you do that over the weekend, and should be able to hold to all of your social engagements. I think the other thing, which is probably one of the things my supervisor said to me, is to make sure that you book out regular holidays in your diary, because life on a day-to-day basis can be quite hectic, can be quite chaotic if you've got a lot on. But the approach that I'm sort of planning to take is to try and work really hard, actually, especially in the week, and maybe work a day on the weekend if I need to, but then every quarter to take at least a week off, where I can go and do something that I really enjoy, take a proper break, actually relax and de-stress, and then go hard again. And that's that's probably where I'm at the moment.
Okay, Natasha.
So this won't surprise any of you that already know me, but the key is holidays for me. I'd pretty much decided this year that I was going to implement my plan of taking 3 months off, not in one big chunk, but various periods across the year. And so I went to Japan towards the start of the year, had to come back about 3 weeks in due to COVID. But I've since managed to get in a sneaky trip to Switzerland, which is quite nice. But I would say holidays are key. What I would say, however, is to always take longer than a week. Because if you take a week off, ultimately you will have hearings booked in for the next week, and so ultimately you will end up working that week. You won't be doing your paperwork, but you'll be doing all of your prep for court for the next week. So always take off more than a week, preferably leave the country, because then clients and your clerks can't contact you and can't try and force you into doing things that you don't want to do. Those would be my tips. The other thing, on a Friday, I'm often found having dinner with some friends or down the pub with other people from chambers, I'd say.
Jackie, tell us you've got some wisdom, something that we haven't cracked yet that you know.
I'm not sure about cracking things, but the way in which you structure your time changes, because the work hard, play hard method was great until I had kids. And then suddenly there's a whole nother layer on life that just actually, and the thing is, when it's just you and an adult, or you and an adult partner, then yes, you can work like crazy and put off the good times to the weekend, put off the good times to the holidays. But actually, when kids can't wait, or as they get older, they can a bit, but you really do have to be quite careful about managing the amount of work you take on, so that you can take off a couple of hours of the evening when you get in from court and then work again later in the evening once you've got them to bed. This is when they're small. You have to be able to do that kind of flexibility. But actually, in order to make that 2 hours of hard work putting the kids to bed, is that's the only break you get, you're going to go mad. So you have to enjoy the normal. You have to take your joys where you can find them in small stuff, and enjoy the time with the kids, or enjoy the time making dinner or eating it and whatever, because actually your weekends get taken over quite quickly, and when you're trying to juggle all the realities of not just leisure and work, but leisure, work and family, gets a lot. So you have to make sure you can enjoy the family and actually do what you can to enjoy the work as well. I know it's stressful, I know it's hard, but actually clients can be quite entertaining if you're sitting around in court waiting to go on. Obviously don't overshare, but you find ways of enjoying what you're doing, whether it's talking to the clients, whether it's researching stuff. If you're very academic minded and you've got something interesting in your case and want to write it up, if you enjoy doing that kind of thing, then writing an article can be a great break and great fun. And it's still kind of work, but you enjoy it while you're doing it. That only obviously works if you're not frantically filling every minute you've got with court appearances. But that kind of stuff, I guess, gets easier when you've got more control over your diary and you're doing fewer, better paid cases with more time to manage your preparation. And I think that's it. It's work hard at the junior end so that you've got the experience, you've got the expertise, so that when you need to manage your time better, when you're longer in the tooth and you've got other people very dependent on you, you're able to be, have a much better sense of how to manage your time and what you need to do and where you need to cut back, so that you can do things enough to stay sane and then come out the other side of it and work hard again.
Yeah, you need to know when to stop, don't you? Because in this job, for any one case, you could spend every waking hour on it until the moment you walk into court. In theory, you could always find something else to do. So one of the things you need to get good at early is working out what's actually important, what do I actually need to do, and what is just fluff, what's just sort of decoration. Because otherwise, if you don't get a good handle on that, you will end up working every hour God sends. And you need to be absolutely shameless and guilt-free in taking all the long lunches you can. When a trial comes out of your diary, just enjoy it, because there will be several weeks where your feet won't touch the floor. And so you just should not feel guilty on the odd day when you're gonna have a sofa day. That would be my advice. Anyway, it's nice hearing from all of you about all these things. And I'm really, really glad that we've had a chance to sit here for an hour and a half and at least talk at you lot. It's a shame we haven't had FaceTime with you, but we are really conscious how difficult it is to get mini pupillages in general, let alone right now. It must be impossible. And we just wanted to give you a bit of our shared wisdom, but also something you can put down on your CVs when there's a question about what mini pupillages you've done. Shamelessly say, well, we attended the St. John's mini pupillage webinar. I know there's lots of other chambers doing similar stuff. We certainly will not be holding it against people that they haven't been able to do minis in the last 6 months, because no one's getting the chance to. And as soon as we can, we'll start this up again face to face, and we'd welcome applications from all of you. But the beauty of what we've had here tonight is over 100 people being able to watch this, when actually in person minis, I think we do one a month normally. So what would have been 12 people max is now over 100 of you. And I hope we've answered at least some of your questions. If there's stuff we haven't dealt with, please feel free to email me direct, or any of us, any of the panel that you think might be able to help you. And I want to remind you about Harriet as well. Harriet said the same thing. She had a really interesting path into pupillage, actually, because she got what's called the Justice First Fellowship. And someone actually asked a question about it, but she effectively secured outside funding for her pupillage from the Justice First Fellowship, effectively a charity, because of the kind of work she was doing, which was very children-based. And so she was basically so wonderful, they decided they would pay her to train as a barrister with us. So by all means, get in touch with us that way. I need to thank Emily and Hannah, because they're our wonderful marketing team, and they have to sit here while we talk for several hours a week, and they have to watch all this stuff. They are paid to do it, but even so, thanks so much for giving up at least a good chunk of your Friday night. Now, everyone, go away and drink wine or eat good food or spend time with your friends. Thanks very much.